Hi, I'm Suzy Rhoades with PassMasters. Welcome to this week's Questions of the Week. This week, our topic is regulation of broker-dealers. You can expect this topic to appear on your Series 63, Series 65, and Series 66 exams. Let's check out our learning management system. We have a 20-question topic quiz. Agents are employed by, choices include investment advisor representatives, broker-dealers, investment advisors, or other agents. Now, when you take your SIE or your Series 6 or your Series 7, FINRA calls you a registered representative, but NASA writes this test, the North American Securities Administrators Association, and they call you an agent. An agent works for a broker-dealer. So you click what you believe is the correct answer. Click check answer. You have the ability to see the explanation as well as listen. It's me. So we do this to appeal to all of the different learning styles that are out there. A business that buys and sells securities for its customers and for its own account would need to register as, choices are investment advisor, broker, broker-dealer, or dealer. So buys and sells for its customers and for its own account. That is the definition of broker-dealer. It's impossible to register as just a broker or just a dealer anyway. It is Form BD that they will fill out to apply for registration. All are true regarding consent to service of process except. So what is false regarding consent to service of process? Always read all four choices. It must be filed annually. It is enforced permanently. It is part of the initial registration. It is required by all persons seeking state registration. So one of those statements is false. And you have two that contradict each other. It is enforced permanently versus it must be filed annually. It is enforced permanently is true. It must be filed annually is false. So you choose the false statement when that's what the question's asking you for. It can feel really strange, I know. So just be careful. When a broker-dealer chooses to maintain its records electronically, all of the following are required except. So one of these is not required. The records must be safeguarded from loss, alteration, or destruction. Seems like a reasonable thing. Access to the records must be limited to persons with appropriate permissions. And the administrator, seems appropriate, must allow for a duplicate backup to exist that is an accurate reproduction of the original record. I do like that. Electronic records must be kept for 5 years. So which one of these is not true? That's it. Broker-dealers only have to keep records for 3 years. Investment advisors keep records for 5. Broker-dealers keep records for 3. There are certain records they keep for the life of the firm, such as Form BD filings, articles of incorporation, or organization are kept for the life of the firm. But otherwise, this is the right answer because it's a false statement regarding broker-dealers. Broker-dealers only keep records for 3 years. Registration as a broker-dealer is done only with the SEC. There is no state registration requirements for firms. Automatically registers the firm as an investment advisor, definitely false. That is not true. Automatically registers the firm's partners, officers, and directors as agents. Oh, I like that. Automatically registers the firm's partners, officers, and directors as investment advisor representatives. No. So the only true statement here, registration as a broker-dealer, automatically registers the firm's partners, officers, and directors as agents. That is true. All are true regarding surety bonds, except So what is false regarding surety bonds? A surety bond provides coverage for the firm and its agents on an aggregate basis. A firm whose net capital meets or exceeds the bond amount will not be required to post a bond. Criminal acts are not covered by the bond. The administrator may require a broker-dealer to post a bond when the firm has custody. So, which of these is false? Criminal acts are not covered by the bond is false. Surety bonds cover lost or stolen money or securities. Criminal acts are covered by surety bonds. Which of the following records does not have to be kept by a broker-dealer? Ledgers? Yes. Blotters? Yes. Business-related emails? Sure. Personal emails? That is the correct answer. Those are records that do not have to be kept by a broker-dealer. All of the following are registration requirements for a broker-dealer except. So which one is not a registration requirement for a broker-dealer? File a consent to service of process. That is a form that creates jurisdiction across state lines, and it is required. File financial statements with the state administrators. Pay federal filing fees. Or have a minimum of 10 years experience in the industry. So they do have to pay federal filing fees, and they do file financial statements in the states in which they seek registration. There is no requirement as far as any experience in the industry. A broker-dealer is new to the state of Utah. When is the firm allowed to do business in the state of Utah? As soon as the firm is granted registration by the Securities Administrator of Utah. I like that, but let's make sure that the others are not correct. As soon as the firm is registered in their home state. After the firm has been in business at least 1 year, as soon as the firm is registered with the SEC. No, if they want to do business in a state, they have to be granted registration by that state's administrator. Registration of a broker-dealer automatically registers the firm's owners as agents when they act in such a capacity. Always. If they have been previously registered as agents, or never. So if the firm's partner, officer, or owner does not act in the capacity of an agent, they won't be registered as an agent. But if they act in such a capacity, owners, partners, officers, directors, they will automatically be registered. It just gets them out of the Form U-4 filing. It does not get them out of taking and passing their Series 63, their agent state securities law exam. Under the Uniform Securities Act, which of the following have to file a consent to service of process? So that's the form that creates jurisdiction across state lines. Choices include agents, yes. Broker-dealers, yes. Investment advisors, yes. Investment advisor representatives, yes. All 4 of those persons are required to file consent to service of process. Which of the following information is not required on Form BD? Name of all prospective hires. What? How could that be? So I think that might be it, but let's check. Just like on the real test, never pick the first right answer. Always read all 4 choices. Test taking tip. Qualification and business history, that is on Form BD. Form BD is the form that the firm, the broker-dealer, files to register. Form and place of business, proposed method of doing business, yes. So name of all prospective hires, no, not on Form BD. A broker-dealer must list on Form BD any judgments and any declarations of bankruptcy within the past. Choices include 90 days, 3 years, 6 months, or 10 years. They will go back 10 years. A broker-dealer's registration expires at the end of their fiscal year, never, April 15th or December 31st. December 31st. Broker-dealers, just like agents, just like IAs and IARs, it's an annual registration. They all expire December 31st. A firm filing for registration in 10 states must file how many consent to service of process forms? 2, 1, 10, or 6. If they are filing for registration in 10 states, they file 10 consent to service of processes. So they're unique to each state. It allows the client that's angry at the broker-dealer in that state to issue a subpoena on the state securities administrator. It's as legally binding as serving it across state lines. So consent to service of process required in every state. So 10. A person engaged in the business of effecting transactions in securities for the account of others is a agent, dealer, broker, or investment advisor. So investment advisor, fee for advice, nothing to do with that. Agent is a living, breathing, natural you, not you. Broker or dealer. Affecting transactions in securities for the account of others. That's when they act in an agency capacity. It is the broker side of broker-dealer. A securities firm that stands ready to buy for and sell from its own inventory at quoted prices is a market maker, underwriter, broker-dealer, or broker. So ready to buy for and sell from its own inventory at quoted prices, that's describing the dealer side of broker-dealer. We also call this a principal transaction or a market maker. Which of the following is not true about a broker-dealer? It may be a corporation, true. It may be an LLC, true. It is an individual. No. Let's check the last choice. It is a person. True. Person is broadly defined. The broker-dealer is the firm. The agent, that's you. You're an individual. So it is an individual is the right answer because we are looking for the not true statement. A broker-dealer with no place of business in this state could do business in this state without registration with all of the following except banks, insurance companies, broker-dealers, retail clients. So what is this question asking? It's basically asking, in order for a broker-dealer to do business in this state, it has no place of business here. When does it have to register here? So there is an allowance for a broker-dealer to do business in another state without registration, so long as it's with institutional clients. So banks, insurance companies, and broker-dealers. No registration would be required for the broker-dealer. But the minute that they have one retail client in a state, they must be registered in that state. So there is no de minimis rule for broker-dealers or agents. The de minimis rule only applies to investment advisors and IARs. So the minute the broker-dealer has one retail client in a state, the broker-dealer must be registered in that state. A broker-dealer registered in Missouri that has no place of business in Arkansas can do business with which of the following in Arkansas without registration in that state? Broker-dealers, yes. So Roman numeral 1 is part of the correct answer. You can get rid of one of the choices. Retail customers. Can a broker-dealer ever do business in a state with a retail customer without registration? Never! So it's not that. So 1, yes. 2, no. So I can get rid of another choice. 3, insurance companies. Can do business without registration with insurance companies? Yes. 4 investment companies? Yes. So 1, 3, and 4, a broker-dealer that has no place of business in this state can do business with institutional clients without registration. That concludes this week's Questions of the Week, Regulation of Broker-Dealers. I hope you learned something. If so, be sure to give this video a thumbs up, subscribe to our channel, and turn those notifications on. If you are interested in checking out our programs or to enroll in one of our courses, there is a link found in this video's description. Thank you so much for watching. I hope to have you as a student soon. Happy studies! You got this.